All right, good morning, everyone. My name is Phil Graham, and I am the chair of the Labor and Employment Practice Team at Sandberg Phoenix, a law firm that's based in downtown St. Louis. This is where my office is, and we have multiple offices, including offices in O'Fallon, Carbondale, and Edwardsville in Illinois, and we practice primarily in Missouri, Illinois, and also in Kansas. But our office here in St. Louis, we're focused on Missouri and Illinois. And so we're excited to be here today to talk to you about the Illinois Biometric Information Privacy Act, also called Bipa. And with me today is my colleague and partner, Natalie Coussard. Natalie?
Thank you, Phil. I am Natalie Coussard. I'm a shareholder at Sandberg Phoenix in the St. Louis office, and I am the chair of our internal class action team and also the chair of DRI, which is the defense bar that is a national group of attorneys. And today, as Phil mentioned, we're going to talk about Bipa. It was enacted in 2008. It's actually the oldest biometric privacy act in the United States. Its purpose is to protect the public welfare through regulation of the use of biometric information and data. And it was enacted primarily because of businesses in Chicago using biometric data. Now, of course, other companies throughout the state have began using it as well. I did want to mention that there is currently a bill in the Illinois House that has proposed changes to Bipa. The first reading took place in February of this year, and it was recently assigned to a judiciary civil committee. No other movement has taken place since then, possibly because of COVID, but we're keeping a watch out for it. Bipa is unusual. Some statutes do not include their intent, but Bipa very explicitly stated the intent within the act. It stated biometrics are unlike other unique identifiers that are used to access finances or other sensitive information. For example, social security numbers, when compromised, can be changed. Biometrics, however, again, we'll get into it, but kind of talking about like fingerprints, are biologically unique to the individual, and once compromised, an individual has no recourse, and they're at heightened risk for identity theft, and they're likely to withdraw from any facilitated transactions that involve biometric data. So because of that, the full ramifications of biometric technology are not fully known today. Biometric identifiers can include retina scans, iris scans, as I mentioned, fingerprints, palm prints, voice recognition, facial recognition, DNA, and gait, so standing. It does not include human biological samples, writing samples, photographs, tattoos, physical descriptions, organs, blood, and other biological materials.
All right, some other definitions that we need to understand under the statute. What is biometric information? The statute says that biometric information is any information, regardless of how it is captured, converted, stored, or shared, based on an individual's biometric identifier used to identify an individual. And the definition of a biometric identifier, which we talked about on the prior slide, is relevant in determining what biometric information is. We're all really used to this technology, because if you have an iPhone or any kind of smartphone, really, I have an iPhone, and I use the thumbprint identification to open my phone and to open apps and to get into other secure portions and applications of my phone. And so that's really the type of information we're talking about here. As of February 18, 2020, the legislature has proposed to exclude from this definition of biometric information any information derived from biometric information that cannot be used to recreate the original biometric identifier. Unfortunately, the legislature has not given any examples yet of when this would be relevant. And obviously that would be helpful for all of us if and when this updated legislation is passed and enacted. All right, we'll go to the next slide. All right, so why are the requirements of Bipa important to know? Well, they are extremely important to know because you can be sued if you're not in compliance with the Act. And Natalie and I are currently involved in some litigation pending in Illinois State Court, a pending potential class action case involving a number of employees of a large restaurant chain franchise operation. And it's become fairly common in your industry, at least in certain areas, to use fingerprint clocks for employees to clock in and out, to access cash drawers, sometimes to access supply areas and other sensitive areas of your locations. So when a company violates Bipa, the aggrieved individual, your employee in this instance, has a right of action against the company. And if the individual prevails on their claim, if your violation is found to be negligence, the company is assessed a $1,000 fine or actual damages, whichever is greater. So the damages the employee can get for a violation is $1,000 or their actual damages, whichever they prove to be greater. And in almost every instance we've seen, employees really don't have any actual damages yet from violations of the Act. So they're relying on the $1,000 statutory damage. However, if your violation is found to be intentional or reckless, the company will be found liable for $5,000 statutory damages or actual damages, whichever is greater. You can also be liable for reasonable attorney's fees and costs incurred by the plaintiff employees and responsible for other relief, such as an injunction to force you to comply with the Bipa requirements. So as you can see, you can multiply those numbers, $1,000 for negligent violations or $5,000 for intentional or reckless violations, by the number of employees you have in your company, and then by the number of violations of the Act. And you can see that those numbers can add up very, very quickly. And then adding in the attorney's fees, there can be substantial penalties, substantial consequences for employers who do not comply with Bipa. So moving on, proposed changes to the Bipa law. Under some new proposed legislation, the legislator would impose greater liability on violators for companies being assessed actual damages, not just $1,000. And then for any willful conduct, companies are responsible for actual damages plus the liquidated damages up to the amount of actual damages. Attorney's fees, costs, and other provisions stay the same. So if this passes and is enacted, we think this would be a positive because it would focus more on requiring the plaintiffs to prove actual damages, not just receiving $1,000 statutory damages. However, the legislature suggested the following protections for companies also. The action must be instituted within 1 year after accrual of the violation, and the individual must give the company 30 days notice to cure violations. And so if the company then cures the alleged violation within 30 days, no action can be brought. So this is what we would call a safe harbor provision. And this is very important and would permit companies to avoid liability for these rather draconian lawsuits if they bring themselves into compliance with the law.
And the majority of cases, as I mentioned earlier, have been filed in Cook County and Chicago. However, St. Clair County is also becoming a popular venue for Bipa cases, as well as some other courts here in St. Louis County and City, and also Madison County. Class action cases can include hundreds or thousands of class members. For instance, if a restaurant is sued, then every employee who passed through there over a several year period who used the time clock could be at issue in the lawsuit. The highest settlement fund we've seen so far is $7 million. The lowest is $35,000. So you can see, as Phil mentioned, there's a lot of money at stake. And those figures don't include the attorney's fees and costs, which are often 35% or more of the judgment. So looking more at some requirements under Bipa, any private entity that's in possession of biometric identifiers or information must comply with Bipa. They must create a written policy made available to the public, establishing a retention schedule. So that's how long that the biometric data is kept on file. Guidelines for permanently destroying biometric identifiers and information. That policy must include that it will be destroyed when the initial purpose of retaining it has been satisfied. So again, if it involves employees, then whenever an employee quits or leaves, then you might have a certain period of time for when the data will be destroyed, or within 3 years of the individual's last interaction with the entity, whichever occurs first. So this policy must be adhered to unless there is a valid warrant or subpoena issued by a court. Under the proposed changes of the bill that we mentioned, the legislature wishes to make the policy available only to the person from whom the information is collected. Right now it's the public, and the information can be disclosed pursuant to a valid order as well as a warrant or subpoena. The order, warrant, or subpoena can be issued from a local or federal government agency in addition to the court. So those are things that are not part of the law right now, but they're under consideration.
Thanks, Natalie. I just want to comment on that last slide on the proposed change to make the policy available only to the person from whom the information is collected and not the public. That would be significant because obviously it's difficult and fairly onerous to do that, to provide this Bipa policy to the public. You need to do that on your website or perhaps publish it and post it in your business somewhere in a prominent place. I should point out that this doesn't just apply to employees. This would apply to anyone, a customer or anyone else that you might be obtaining biometric information or identifiers from. But we've mostly been kind of talking in the employee context because that's where we've seen a lot of the action in the litigation, and it seems to be focused on that. All right, so moving on with some other requirements under Bipa. No private entity can obtain biometric identifiers or information that we've talked about unless the following requirements are met. So here are the compliance issues. 1, the individual must be informed in writing that this information and identifiers are being collected. 2, the individual must be informed in writing again of the specific purpose and length of term for which this information will be collected, stored, and used. And then the individual must sign a written release of that information. So these are all the 3 primary points of compliance at this point. The information must be in writing, inform the individual of the specific purpose and length of term for which it will be collected, stored, and used, and they must sign a release of that information. Under the proposed changes in the legislation that are pending right now, if that were enacted, the individual must sign a written consent, not a release. That's a little bit different. A release would be something that would release and allow the collector to use that information outside of the employee. The consent is a little different. It's a little bit easier. And the written consent may be obtained by electronic means. Both of those things would be very helpful to employers and businesses. All right. Also, no private entity may do the following with biometric identifiers or information. They may not sell it, lease it, trade it, or otherwise profit from it. They may not disclose it, redisclose it, or otherwise disseminate it. So if you're collecting your employees' fingerprints You can't sell that information. You can't use it any other way except in your own business for your own purposes. However, dissemination of the information or identifiers may occur where the individual consents, or it may be required by state or federal law, or if it is required pursuant to a valid warrant from a law enforcement agency or a subpoena issued by a court. Okay, kind of wrapping up under the requirements of BIPA. Every private entity in possession of a biometric identifier or information must do the following. They must reasonably store, transmit it, and protect it from disclosure. They must store, transmit, and protect it from disclosure in the same manner or in a more protected manner in which the private entity does for other confidential and sensitive information. So if you think about your personnel files and the information you maintain in those, including payroll information, you may sometimes have separate medical files for employees that you're keeping on a confidential basis. The biometric information and identifiers you protect must also be protected in a similar manner so that the confidentiality of it is protected and so that it's not disclosed. So, protecting it in a way that it's not subject to, reasonably subject to hackers or those that might be up to nefarious purposes by getting into your system. So you've got to take steps to protect what you obtain.
Thanks, Bill. Okay, so I'm going to talk about a few definitions. We've been using the word private entity. What exactly does that mean? When we think of entity, sometimes we're thinking about a company or corporation, but it also, the definition under BIPA includes individuals, partnerships, corporations, LLCs, associations, and basically any group, however they're organized. It does not include state government agencies, local government agencies, Illinois courts, clerk of courts, or judge or justice of the Illinois courts. So basically that means anything having to do with the Illinois government are not covered, but any other individuals or companies are. Phil mentioned written consent. What does that mean? Basically, it's any informed written consent. However, when it is in the context of employment, it can include a release executed by an employee as a condition of the employment. Earlier this year, the legislature proposed to strike out the language regarding the employment release. This means that the only type of written consent will be the informed written consent. So they have to be informed that their biometric information is being used and for what purpose, and sign off on that before the company is able to collect their fingerprint or whatever they're going to be using. So BIPA does not impact discovery in any court action. It also does not apply to several Illinois statutes, including the X-ray Retention Act, HIPAA, which mainly has an impact on the healthcare providers, financial institutions subject to the Title V of the Graham-Leach-Bliley Act, private detective, private alarm, private security, fingerprint vendor, and locksmith act, or the contractors, subcontractors, or agents of a state agency or local government when working for that state agency or local government.
Well, let's talk about, again, some of the proposed changes to the construction of BIPA. The proposed changes by the legislature of BIPA will not apply to contractors, subcontractors, or agents of a federal agency when they are working for that federal agency. It also, if they are enacted, will not apply to private entities if the private entity's employers are covered by a collective bargaining agreement that provides for different policies regarding the retention, collection, disclosure, and destruction of biometric information. So if you've got union employees and you've got a collective bargaining agreement, some of them are now starting to deal with the collection of biometric information. So it would be important to check those and look at the union rules with regard to the collection and retention of biometric information. Because if these changes are enacted, those will control over the terms of the statute itself. All right, we want to talk about a little bit about other states with biometric laws, because Illinois is not the only one who has gotten in on the action with these types of laws. Texas, in 2009, passed its own Biometric Privacy Act, and under it, a person may not capture a biometric identifier without prior consent, may not sell biometric data without consent, or unless allowed by law, must use reasonable care in storing it, and shall destroy the biometric identifier within a reasonable time. Under the Texas law, there's a very steep civil penalty of $25,000 for each violation without making a distinction necessarily between negligent and intentional or reckless acts. However, the saving grace in the Texas Act is there is no private right of action. Instead, only the state attorney general has enforcement rights. So that's the difference there between that and the Illinois law, is that in Illinois there's a private right of action, whereas in Texas there is not.
Thanks, Phil. For Washington, just a couple of years ago, 2017, Washington enacted a biometric privacy legislation. It prohibits any company or individual from entering biometric data in a database for commercial purpose without first providing notice, obtaining consent, or providing a mechanism to prevent the subsequent use of that biometric data for commercial purposes. Again, like Texas, though, there's no private right of action, so you cannot bring a lawsuit, and instead the Attorney General is authorized to enforce this law. For California, more recently, this just went into effect this year, they enacted a California Consumer Privacy Act, which regulates biometric data by including it in the definition of personal information. So the California Consumer Privacy Act defines biometric data very broadly to include psychological, biological, or behavioral characteristics, including DNA that can be used to establish individual identity. That includes imagery of iris, retina, fingerprint, face, hand, palm, vein patterns, and voice recordings. It can be anything that can be extracted, or a keystroke pattern, or rhythms, gait patterns, sleep, health, and exercise data that contain identifying information. So you can see right now it's much more broad than the Illinois definition. And for New York, it recently amended its existing data breach notification laws. It's called the SHIELD Act, and it broadens their definition of private information so that it now includes biometric information. It includes the same types of things like we've discussed before: fingerprints, voice prints, retina or iris images, and other unique physical characteristics. Earlier, New York had passed a limited biometric legislation, which applied specifically in the employment context. As you've heard throughout here, that's where we see it most often. It prevented fingerprinting as a condition of securing employment or continuing employment. New York does not expressly provide for a private right of action. And finally, Arkansas became the latest state to pass biometric data legislation. It amended its breach response laws by revising the definition to include personal information and biometric data. And it includes fingerprints, face prints, retinal or iris scans, hand geometry, voice print analysis, and DNA, and other unique biological characteristics.
All right, great. In sum, so to sum up here, to protect your company, the first thing you should consider is whether using biometric data will be necessary or appropriate for your business. Is it going to be really something that the cost-benefit analysis will benefit your use of it, given your potential exposure under the Illinois Act, or if you're doing business in any of these other states, your exposure under their acts, but particularly in Illinois, given the private right of action. If you are relying on biometric data, or if you're going to, or if you already are, make sure you're providing advance notice to those individuals and obtained their written informed consent. Ensure that the notice you're providing adequately discloses why you're collecting the information, how you're using it, how you're storing it, and how and if you're going to disclose that biometric data to anyone else. All of your biometric policies should be included in your employee handbooks or manuals or written policies and procedures. And you should allow individuals to opt out of the biometric information collection. This can be a little challenging in the employment context if you're using it for employees to clock in and out or for other purposes, but you need to make arrangements for those folks that opt out to be able to do that in another way. It's important also to stay informed of the latest developments in this area. Work with your attorneys and your advisors on implementing, updating relevant policies and procedures, because as we've indicated, this has become a really hot topic of litigation recently, in part due to a fairly recent decision of the Illinois Supreme Court that really opened up the damages and made the damages easy to obtain and easy to prove. And really, we would argue a little bit of editorializing. We would argue that it makes it really almost a strict liability standard. So it's important to be aware. It can get expensive. It may or may not be covered by your employment practices and liability insurance or your other insurance. And so you could be, not only in a complex lawsuit, but also on the hook personally and individually, or your company could be for not only liability exposure, but defense costs as well. So we thank you for allowing us to present today. When we set this up, we anticipated being able to be with you all, but I think that was in February, and that was, of course, before COVID-19 changed all of our worlds, and all of you in the restaurant business have been through a lot more than others, and so we really appreciate still being able to present this information to you today, and we hope it's helpful. And if you've got questions, we're certainly available offline. You can contact Natalie or I, and we'd be happy to walk through any of these compliance or other issues with you. So with that, we thank you.
Yes, thank you so much, and thank you for bearing with us with this new technology.